moment, and we're going to begin with the crime and policing bill.
We are, and I should say at the outset, this is not going to be exhaustive because there is simply too much contained within it. But the Home Office and the Home Secretary have been turning out oblique references to this crime and policing bill, which was laid before Parliament yesterday, but without giving any clear idea of what may be lurking within. So we see Yvette Cooper here, and the show notes will contain links to the government's own descriptions of what the bill aims to do and why they consider it necessary. The UK column will aim to point out some of the dangerous infringements upon liberty which appear to be proposed by it. So the Home Office says the bill will give police powers to enable them to reduce the abuse of women and girls and children, especially sexual abuse, and the dangers posed by artificial intelligence, though the government is keen to embrace it. Something of a contradiction there. Now, central to the provisions in the bill are the conflation of antisocial behaviour and terrorism, as though it is but one small leap from one to the other. Like the majority of government legislation in the modern era, the offences which are being described as being created are to be found in existing legislation, making this an example of the simple justification for the extension of police powers and intrusions into our lives. To illustrate this, the definition of antisocial behaviour concerns the causing of harassment, alarm and distress, which are the exact terms covered by sections 4 and 5 of the Public Order Act 1986. So I would put it that the reason for this is, or the reason that it's rehashed, is to justify a range of orders, one of which was mentioned some weeks ago, and that's the respect order, which may bind the subject to refraining from or committing to certain activities. Now, these are passed down by courts, but they may be applied for by a very wide spectrum of organisations, including among their number housing providers, the Environment Agency, Transport for London, and the National Health Service. So for this to be the case, the bar is set extremely low, and an order may be granted if, quote, the court is satisfied on the balance of probabilities that the respondent has engaged in or threatens to engage in antisocial behaviour, and the court considers it just and convenient to make the order for the purpose of preventing the respondent from engaging in antisocial behaviour, end quote. So this would be to make it legal to engage in tackling pre-crime or indeed thought crime, and it is illustrative that the words just and convenient are used, as such a measure could never really be described as necessary and reasonable, which should be criteria that do of course follow such interventions. To contextualise the suggestion of such powers, it should be pointed out that the Labour MP Mike Amesbury, who's currently serving a 10-week sentence for punching someone in the face, is still on full pay as a Member of Parliament and faces no formal sanction against holding that parliamentary appointment. Now, another area of many deserving very close scrutiny are the apparent confusion of powers of entry and powers of seizure, upon which the police could have conferred upon them, with a special regard to bladed articles here on screen. As it stands, Section 17 of the Police and Criminal Evidence Act 1984 confer powers of entry for police, specifically in pursuit of someone they're trying to arrest, but only if they believe, rather than suspect, that that person is on the premises. This also applies to the preservation of life or limb. But this new bill guarantees or grants warrantless seizure of bladed articles, as seen a moment ago on the screen. Now, this suggests that a constable who is lawfully on any premises finds on the premises an article which has a blade or is sharply pointed, a relevant article, and has reasonable grounds for suspecting that the relevant article would be likely to be used in connection with unlawful violence. So, subject to an awful lot of decision-making by the particular constable who may be on the premises. What muddies the waters here considerably is that it then goes on to say if there is no person on the premises, they must leave a record of what was seized in a prominent place on the premises. Now, this prompts the question, what exactly would a constable finding themselves on a premises, how would they be able to justify what can really only be described as a fishing expedition? And given what Idris Elba was saying recently about the banning of all knives, it's not really hard to see how circumstantial evidence could be gathered and indeed by exploiting this provision when attempting to build a case against somebody undesirable. If even kitchen knives may be considered as articles to be used in connection with the unlawful violence that's described. So the present situation is that police are bound to limit any search according to specific criteria, the most important of which is to look only for the object of the search. So this bill would completely change the situation, and it should be expected to be challenged in the strongest possible terms. Other areas of the bill do deal with children specifically and apparent measures to protect them, also, we're told, which we'll unpack in due course. There's not really time for that today. But what I would like to draw your attention to is the predicted drifting of the definition of terrorism, even concerning people between the ages of 12 and 21. And under the heading of youth diversion orders, it's now introduced that serious harm may be taken to constitute terrorism, completing the move away from any sort of ideological basis for the action or the threat of action. Now, this is a direct exploitation of the Rudakabana case concerning the stabbing of children in Southport, and it follows the theme of using the tragic circumstances of families to introduce measures to strip away liberty. And recent examples just on screen now, Ronan's law, Martin's law, and Raneem's law are all very much emotionally charged with which to justify powers which had not previously been given serious consideration. So, I mean, in summary, there'll be much more to examine in this bill over the coming weeks, but certainly at this stage, making noise about these issues, and in particular, the ceding of liberties against offences that are already on the statute book is critical. So this bill looks very much like it is an exercise in going over offences that are already written down purely to allow police to conduct themselves in ways that have hitherto not been possible, and indeed to strip away liberty that really should be preserved.
Thanks, Charles. Let's move on then to